Greetings and salutations. Welcome back to another instructional episode of the Legal Beagle podcast. Today, Brandon and I will be talking about originalism and textualism in the context of the Canons of Statutory Construction from Justice Scalia's book. It's going to be an interesting one. It's going to be a two-part series. So today, you'll get the first part, and next Thursday, you'll get the second part. So without further ado, here's Brandon. Welcome back, Brandon. Day 3. This is the third instructional study. And what are we talking about today?
So we're going to continue building on the foundation of using originalism and textualism as our base foundation of interpreting statutes and applying those to regulatory agencies. But also, we're going to go back and forth between this philosophical difference that has been with us since time immemorial. And what I'm talking about here is, again, for people who haven't come before, is the idea incorporated into our Constitution, which rights are endowed by a creator outside of man, or it's just a form of statism, whether that be protectionism, socialism, communism, postmodernism, it doesn't matter. But what we'll see today as we go back and forth, and especially we're going to work our way from Roscoe Pound into Woodrow Wilson, the creation of the administrative state, and how the administrative state uses rules and regulations to navigate our constitutionally secured rights. And it's been done for the last 100 years, so most people cannot even articulate how it's being done. However, that's not you, that's not me, that's not Gary now, because we're going to see how interconnected the rules of grammar, rhetoric, and logic are, and how to write effective pleadings is going to be learned in this too. So without further ado, we're going to start off with Alexis de Tocqueville. And then I'm going to read a quote from Charles Hegel. It's funny, you wouldn't think Hegel's involved in American politics, right? However, if people do not know, Woodrow Wilson, the first quote-unquote intellectual president of the United States, was an ardent student of Hegel. Okay, so let's go back in time. Alex de Tocqueville on Democracy in America, and this was the quote at the time Alexis spent his time here. Alexis de Tocqueville perhaps started this trend when he observed in the United States distinctive qualities of individualism, associationalism, localism, and decentralization, but not many inklings of a modern state. This is his quote. The federal government of the United States, he mistakenly surmised in the early 19th century, is tending to get daily weaker. Stage by stage, it withdraws from public affairs, continually narrowing its sphere of action. Being naturally weak, it gives up even the appearance of strength. So what he had surmised that the statists had backed away from trying to ensnare the United States. So we'll go to Hegel on the United States. And the philosophy of history, George W.F. Hegel. And this is his perspective of the United States. You froze, Gary.
Oh, I might how about now?
There you go. So Hegel questioned whether the United States was a real, capital S, state at all. As he noted, general object of the existence of this state is not yet fixed, the United States, and determined. And the necessity for a firm combination does not yet exist. For a real state and a real government arise only after a distinction of classes has arisen. Let's back that up. Let's get into our cultural Marxism, the divide and conquer ideas. A real government arises only after a distinction of classes has arisen. Without the class dynamics of the old world, remember I keep talking about pre-modernity, right? They want to go back to the old feudalistic systems. Without without a feudal aristocracy, without a military nobility, or an elite corps of state civil servants, and without the reception of Roman law. I'll actually speak on the Roman law in just a second. What could one possibly talking about by referring to an American state? And so one of the things that we see with the ever encroaching of the Roman law is the doctrine of parens patria used by CPS, a multitude of different agencies, whereas parens, the father, the patriarch of each child, is actually the state. Okay. And that's the doctrine of parens patria. That's a Latin terminology. So with that, I'll jump over here and we'll start building on our previous study.
Yeah, I saw Tulsi Gabbard doing an interview the other day, and she was saying that Hawaii was the feudal system, like almost after it became a state, because there was only 4 large landowners that, they were using the competition between the Japanese and the Hispanic and whoever else that came there to try to farm everything. And she's like, yeah, it was pretty much feudal, way longer than you might think.
Right. And I would imagine so. So last week we went to Title 26, 7701, and we started with the plain ordinary meaning. We defined the word construe, and we used the exhaustive list canon, and we used the associated word canon. Let's get a little bit more technical now. Okay. So we're going to read it again. When using this title, we're not otherwise distinctly expressed or manifestly incompatible with the intent thereof. Person, the term person shall be construed to mean and include an individual, a trust, a state, partnership, association, company, or corporation. So we saw the exhaustive list canon last week. We saw the associated words canon, the doctrine that associated words bear on one another's meanings. We're going to introduce a new canon, expressio unis est exclusio alterius. The expression of one thing is the exclusion of another. It's also called the negative implication canon.
Which kind of goes into the definition of include in the legal terms, right?
That's where we're going.
Gotcha.
Exactly, Gary. So the exhaustive list canon and the associated words canon meant that an implication could come in with the corporations up here, right? That could include nonprofits, or any other type could be included in this definition because of the exhaustive list canon and the associated words canon. But let's pinpoint a little bit further why it's not just the associated words canon that excludes you and I, the individual. Okay. And it's going to be found here with the expression of one thing is the exclusion of another.
Now, are we going to note that certain titles can define these words differently for that title exclusively?
Well, that's a great point of distinction. So when you go read Title 26, which is the IRS code, you can't use the definitions there over in Title 5, which is the enumeration of the rights of federal employees. You also can't go use that in the criminal statutes because most criminal statutes, and especially in Louisiana, they identify the natural person.
Right.
And we'll get to this idea later, the judicial activist granting corporation rights. But just stick this in the back of your head. A corporation has no rights, and that it's a non-living entity because rights are endowed by a creator. So what they're saying when they give corporation rights, that the sovereign is who? The state.
Oh,
yeah. So the state
Ultimately
incorporates everything. So they're back to Hegel, Nietzsche, Marx, whichever one, Foucault. The state is this actual sovereign, but that's not true in individualism. It's we the people are the sovereign. However, that's a later date and time. We'll get into that. So first, let's express something: to utter, to declare in words, to speak. He expressed his ideas or his meaning with precision. And we're going to use our words like little bullets. right? You're going to come in there and you're going to start learning to articulate specifically. To this point, and the probably 14 attorneys that Gary and I have faced, nothing is specific. It's just like a paintball gun up against the wall. Pop, 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 pop. Everything's outside the pleadings. Watching my YouTube videos, everything has been excuse, 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 and not one direct refutation of who and where granted these people this authority to violate our individual right to life, liberty, and property, whether by COVID or by takings of the takings clause of property, or by whether unreasonable searches and seizures. It doesn't matter. Not one has actually gone after the complaint and actually said, okay, well, here it is right here. This is where it's enumerated, because the great bait and switch that is American politics right now, and it is a bait and switch, because most people are so fundamentally lost in the area of knowledge and wisdom and intelligence. Of course, that was the design of education anyway, was to reduce us all down to the same standardized citizenry. Most people do not understand the difference, but something different, simple as the difference between a right and a privilege. Okay. And if you can't do that, you need to learn to define the words. We are originalists and textualists. We are not conceptualists or using Viperine interpretations like Thomas Hobbes said. I'll define Viperine interpretations here in a little while. Okay, so he expressed.
Let me say before, real quick, that just these universities all standardize all this education, and in order to be accredited, who accredits the university? Government. So government determines what curriculums are deemed okay to be taught in these accredited. And if you're not in an accredited university, then you have no credibility in the real world.
And the one thing why we're going to go back and forth between philosophy and law is because it baffles my mind that there isn't someone in America that hasn't challenged the religious practice of secular humanism, Marxism, or any of these other isms as a violation of the church and state doctrine, because they are religious in practice.
Only people on the right can violate the separation of church and state.
Yeah, that's right. And the truth is that they're all theoretical assumptions that we have receipts over the course of time that are complete and utter failures. Okay, so we'll just take the last 400 years of history and say they're factually correct. Okay. One of the things that is factual: when men were free, we created. Okay, and it doesn't matter what data set you go to from the 1800s till now. In Western cultures, the standard of living has increased 200-fold, and yet those people who are stuck in isolation or in backwards countries are still living this life their same way. Okay, the standard of living was increased here with freedom and the right to life, liberty, and property. Because once man's free, he's able to create without somebody else coming in and stopping him through religious doctrines. It doesn't matter if we go to the Dark Ages with Catholicism, to Caesar, to Marxism, whatever. The only thing that they do is can steal other people's ideas, because you don't have the freedom, the artistic expression from man happening organically. It's forced. So with that said, we're gonna include the Justum Generous Canon here. Also, where general words follow an enumeration of two or more things, they apply only to persons or things of the same general kind or class specifically meant. Okay, so let's explain. Let's go a little bit deeper than that, and I'll scroll back up. The rationale for the Justum Generis Canon is twofold. When the initial terms all belong to an obvious and readily identifiable genius, one presumes that the speaker or writer has that category in mind for the entire passage. So when you start thinking legally and lawfully, you think of in terms of genus and species, right? So if we have a genus already identified, then we can use the exhaustive list canon to include species of. Okay, does that correlate? Does that make sense, Gary?
Right. So you can't be talking about airplanes, boats, and cars and then put ducks in there.
Right.
That doesn't go. One's 3 are transportation and one is absolutely out of the ordinary.
Right. And we'll see this here in a little while. Because this is going to be a 2-part study for everybody that's involved. It has to be. It's too much information in one go. But we'll see when we get to the CDC, the Freedom Health Defense Fund versus Biden, and the CDC ruling that this is exactly how the judge tore apart the CDC's mask mandate for on transportation, because there was no enumerated authority given, which it couldn't be anyway, because that would allow for arbitrary and capricious seizure of anybody in the world. But let's just talk about the word sanitation that was used to include people, when the enumeration, the legal authority given to the CDC was for property and objects. Okay, so he used them generous. It's not the same genus. It's not even within the same species. And of course, we're going to delve further into this with the Chevron deference as we move forward, and why it's such a dangerous doctrine for all Americans. Okay, so in legal terms, the word genus is used to describe a general category that includes several specific types or species. Okay, that's the simplest way I could break it down for people. We have previously tackled the importance of construction construed, but now we move into a slightly more technical field, which requires multiple canons to interpret the text correctly. So let's go back up here and we'll look at the text. The term person shall be construed to mean and include. So the expression of one thing is the exclusion of another. An individual, a trust, a state, partnership, association, company, or corporation. We use our associated words canon. Okay. Then we're going to move into adjustum generis, right? And a thing, we're going to use genius right here. So everything that is associated with the first couple of words must follow, must be of the same genus. So individual, by statutory interpretation and the rules of interpretation, cannot mean you or I. Okay. Now, whether these administrative courts do it that way or not, that's a different story. But we have to understand the basic principles of constitutional law, common law, and the rules of grammar. Okay. And these have been practiced since William Blackstone, going way back. And what you have here, let me pull this up real quick, because I want to talk to people about this, because this has been going on a lot longer than what people think. Let's do what is called a mischief rule. There we go. I don't know who she is. So this is what they're doing. So when they enter their own conceptualization, a judge biasly enters their own interpretation. One, it's a Viperine interpretation. I'll read that next. But it's also called the Mischief Rule, and it's been going on a long time. The literal and golden rules are concerned with finding out what our Parliament said. The Mischief Rule is applied to find out what Parliament meant. It looks for the wrong, the mischief, which the statute is trying to correct. The statute is then interpreted in light of this. This rule is based on Hayden's case, in which certain steps were identified as a way of interpretation. So we're going to throw away the plain ordinary meaning, the golden rule, and we're going to conceptualize what we want it to mean versus what it actually means. And it causes great harm to the individual. So with that, I want to turn everybody's attention. Gary's going to put this in the show notes. So let me back off that a little bit so everybody can see it. This is a great tool, an asset to have in your library. This is the PDF version, but I want to show people a few things while I'm in here. This PDF version has hyperlinks, okay? You'll see that it hyperlinks to your particular section. Okay. What I want to tell everybody now is you're going to see me read from the definitions, right? A thing not expressed is implied. So what I do is spend a lot of time in a dictionary. And I've been doing that for years. And it's taken years and years of unlearning, like Yoda. To learn, you must unlearn, right? Because we've all been programmed with the same dumbed down education. And I'll give a great example right here. In one of Gary's and I's first lawsuits, I don't know if it was the first or the second, or maybe even the one against Judge Shelley Dick, I used the terminology, the spirit of the law. And I remember it to this day because at the time, I didn't quite understand what the spirit of the law actually implied.
It was against the Mississippi Band.
Okay. Yeah. And so the spirit of the law is a conceptualized interpretation, right? It's up to the subjectivity of the person and what they mean by it. And we'll talk about this too. If you hear people say the living Constitution, right? It's not living. It is dead, dead, dead. Living Constitution means that men's nature actually changes over time. Man's nature doesn't change. It's fixed and mutable. We have the capacity to do greatness, and we also have the capacity to inflict great misery. Okay? That's the infallibility of man. These people that project this utopia worldview that the perfect system is going to come in place in the perfect state, and we're going to usher in singing Kumbaya, are not living in reality with us, because all we have here is men. That's it. And that includes females, right? And as such, when you hand power over to a select few, you think you're going to get that power back easily, or they're going to be altruistic with all their intentions? Well, you might get a good king like Marcus Aurelius, but your next one could be Nero. Okay. So with that, let's do consequentialism, an interpretive theory that assesses
and blow that back up a little bit.
Okay, thank you, Gary. How about that?
Yeah, that's better. Yes.
Okay. An interpretive theory that assesses the rightness or wrongness of a judge interpreter's reading according to its extra textual consequences. See section 61. Okay. We're going to go ahead and read purposive construction, an interpretation that looks to the evil that the statute is trying to correct. Think Mischief Rule, i.e. the statute's purpose, usually conceived broadly and apart from the limitations of the text. Okay. And I want to get down to the Viperine. So hard to go through here when it's this big. Where is it? Oh, that's a good one too. We'll read that one too. Spurious interpretation. This comes from Roscoe Pound. And if anybody hasn't heard of Roscoe Pound and his involvement in the social engineering aspect of lawyers, he's a Harvard man. You can always find a Harvard man behind each and every tragedy that besets America. Fact.
Yeah.
You can always find a Harvard man. According to Roscoe Pound, spurious interpretation puts a meaning into the text as a juggler puts coins or whatnot into a dummy's hair to be pulled forth presently with an air of discovery.
And the Harvard man will always tell you he's a Harvard man.
That's right.
In almost every sentence, he's going to bring up, I went to Harvard.
Yeah. It doesn't take a Viperine interpretation that essentially destroys the text. This is what Thomas Hobbes said in 1651 about the phenomenon without actually using the phrase. So people tend to believe that they're living in a special time with special needs and that this battle hasn't waged on forever. It's false. This is a philosophical battle that has waged on since time immemorial. Okay.
Some would say spiritual.
Yeah. Well, that's right. That's right. It is. And it's hard for people to understand this when they lack the fundamental understanding of the natural world first, right? And you hear people say natural law and natural law and natural law. But if you have no fundamental basis to put that on, it just means some empty platitude, right? What does natural law consist of? Well, that reality is here. Okay. And my intent, my choices, and my actions that directly impact another life, liberty, and property is a violation of the natural law because I'm a man of faculty. Okay. Go back to individualism versus collectivism and go through that a few times until you actually incorporate that into your entire system and understand what the golden rule actually means and why we apply it through our law. Thomas Hobbes said in 1651 about the phenomenon, without actually using the phrase, by the craft of an interpreter, the law may be made to bear a sense contrary to that of the sovereign, which means the interpreter becomes the legislature. Oh boy, where is that happening at? And that's happening in a multitude of ways, right? Anytime a doctrine's introduced, whether it's strict scrutiny, whether it's the Hicks doctrine, whether it's a multitude of other doctrines, whether it's a Chevron deference doctrine, these are ex post facto laws created by the judicial branch, United Steelworkers, Kelo versus New London. Go read these cases. Be able to articulate why they're wrong. Kelo versus New London, the Supreme Court in that case decided that they were going to extend public use to mean public function. Now, there's a big difference between public use and public function. They traded private land to a private contractor for public functions. This meant that they could come in, build a mall, tear it all down, build apartment complexes. That's a direct violation of the Constitution of the United States and the Takings Clause. However, we've got,
which is just like like carbon pipeline they're trying to build in Iowa. You know, they're going to try to use eminent domain to take land for a quote unquote public good, but farm it out to a private corporation to make money.
That's right. So the top-down approach is your fascist movement, and this is through private-public partnerships. Your bottom-up approach is the cultural Marxism, class warfare, and things of that nature. You must be able to see both of them working at the same time. And there's no answer. Gary hit the point of this last week, and I'll go ahead and read a quote from Hitler here, just so people understand the theology.
YouTube shadow ban, here we come.
National socialism is the determination to create a new man. Okay? There's no new man. There's just man. Okay? There will no longer exist any individual arbitrary will, nor realms in which the individual belongs to himself. The time of happiness as a private matter is over. I want y'all to let that seep in. Okay? Those out there seeking a ruler shall get one, but he won't be the benevolent one they want. Okay? To direct all your power towards an agency, instrumentality, organization, or government is to willfully subject the individual rights, liberty, and property to the whims, dictates, and passions of another man, because the state isn't running anything. Okay? It's just you and I. If you can get that fundamental concept through, you'll stop wishing governments and states and anointed rulers will rule you. Okay, so let's read here from Max Weber. And all I'm doing is giving y'all ideas here of how it's happened. That way it correlates with the statute text. Okay, that's what I'm doing. How it happened, how it was brought about. That way you can go back and verify everything Brandon says. The decentralized power of the federal government would be upended in the early 20th century by social reformers and men of learned understanding. That regime was upended by the hidden revolution in government that forged a distinctly modern state in the United States after the Civil War. That hidden revolution consisted of several interrelated components, including new conceptions of public good, public purpose, and a redefinition of a new active liberalism for an industrial age, an increasingly positivist idea of law, legislation, sovereignty, and the very notion of a state as a legal entity itself. A radical expansion of the ideas of police power, administration, public management, and administrative regulation, and an increased governmentalization of political and democratic processes. We'll talk about Max Weber. And I'm just going to read this. Max Weber's ideal definition of a modern state. correlate this with Hegel, correlate this with Hitler, correlate this with Kant. It doesn't matter which one, Foucault, correlate what they are. Their status first and foremost. Doesn't matter if it's Marxist conception that God must be destroyed, or Hegel's that the divine reality lives within the state. That's a direct quote from Hegel too. A rationalized and generalized legal and administrative order amenable to legislative change. Before this time, Roscoe Pound, the Harvard man, Max Weber, Woodrow Wilson, and these people, the administrative state was not thought about. Okay. A bureaucratic apparatus of officers conducting official business with reference to an impersonal order of administrative regulation. The power to bind, to rule, regulate all persons, national citizens, and all actions within its official jurisdiction via its laws. And number 4, the legitimate authority to use force, violence, and coercion within the prescribed territory as prescribed by the duly constituted government. This was Max Weber.
And
the theory.
So Woodrow Wilson wrote a book called Administrator, where he basically admits in very much detail that he wrote the book to bring in the administrative state and to subvert the rule of the Constitution. This was our president, our U.S. president, 100 years ago, 100 plus years ago at this point.
Yeah, and he was a Democratic, world-renowned Democrat socialist. But, you know, so when there's a great passage in the Bible about those who have whispering ears or something of that nature. I can't remember now. But the things that sound good and the things that sound pleasing and may look like a bowl full of flowers, in reality, they're usually putrid, stinking, full of excess bones, right? There's an ulterior motive behind the use of public monies to destroy poverty or whatever goal it is of government come in and solve. I mean, it just creates a government largesse and incompetence. Ronald Reagan was right. The 9 most scary words, the 9 scariest words you'll ever hear is that we're from the government, we're here to help. That was a true statement by Reagan, right? And so this was Max Weber, the theory of social and economic organization. The reason why I bring this up, folks, is that way back in 1912, 1915, and around the turn of the end of the 19th century, social engineers were already starting to work to destroy the idea that is America, because their belief system is contrary to individual liberty, life, liberty, and property. Okay. So just give you something to think about as we continue on our lesson here. Okay. That's not the one, Brandon. You goofball. So we'll continue on. Individual, trust, estate, partnership. These terms are specific, expressed, and identify a particular genius which the term person applies to. And the inclusion of one genius is the exclusion of another. Very simply put. It's not hard. So I want to read now from my book instead of going back and forth. So it's a little bit faster. So what I want to do is give everybody the actual definition of originalism. Okay? Originalism is the doctrine that words are to be given the meaning they had when they were adopted. Specificity. The canon that a legal text should be interpreted through the historical ascertainment of the meaning that it would have conveyed to a fully informed observer. Capture that again. A fully informed observer. At the time when the text first took effect. The doctrine that a legal text should be interpreted to affect the intent of those who prepared it or gave it legal effect. Since one is our preferred use of the term, it is I'm going to say this. It is an objective test. Nobody can go see inside the mind of the legislature and what they thought. Right? It's impossible. So we're going to tie that with textualism. Textualism is the doctrine that the words of a governing text are of paramount concern, and that what they convey in the context is what the text means. So we'll move that on out the way. I think we're going to be done with that for a little while. So originalism in action. So for those of you don't know, I'll do this real quick so everybody can see that I'm not just cutting and pasting whatever Brandon wants to. Of course, a great deal of funds have been spent by Gary and I to get to this point, by the way. And then we turn around and as we have received freely, we give it freely. So before we go any further, I must explain what the red flag is. Okay. And we're going to go read that together because I don't want anybody to think I'm citing a case that's irrelevant. And this is important. This is one of the cool things about Westlaw that you don't get in other places because you get to go verify what it is. So Gary and I have faced this already. But I want y'all to see it too. I'm going to zoom that in. So why is it red flag? So the holdings, the Court of Appeals, Wilson Circuit Judge held that the expiration of HHS declaration of COVID-19 public health emergency rendered the case moot. We faced that too in our injunctions because Shelley D. Dick, once we sued her, finally removed her mask law and our vaccination status. Action did not fall within scope of voluntary secession exception to mootness. We tried that too. And action did not fall within scope of mootness exception for actions capable of repetition, yet evading review. We tried that also. So I just wanted people to see that, why there's a red flag there on the case. And that's because the continued, they wanted to not just get the injunction. Okay. And this is something that's got to be pushed by all of us. Look, listen, folks, COVID-19 was a military operation from the word go, including private corporations and international organizations. They shut down the entire world using emergency use authorized directives and countermeasures. This is military terms. The DOD taxpayers bought every vaccine. They were disseminated from the DOD out. Okay. This was a military operation in America.
Meaning that the DOD owned all the vaccines. They bought them all and disseminated them to whatever, healthcare people that were going to administer them. But the U.S. government bought and owned all of the vaccines to begin with. Very important to know.
And we'll go ahead and talk about this fine point right here too, because we're not going to get to it in the next two studies. But I just want people to know the importance of some of these cases that are happening. So the FDA lost its lawsuit for ivermectin. Most people haven't put it together yet, the importance of that.
Huge.
For an EUA directive to go out, there can be no alternatives available. So let's put this in layman's context. The reason why the federal government, YouTube, social media companies, and all went on a mass line effort, go look up Mao Zedong mass line effort, and attacked anybody in the United States who spoke up about alternative methods and stopped the Barrington Declaration and things of that nature about ivermectin and hydrochloroquine and everything else, was because if there was an alternative, there could be no EUA. And so we'll go through that at a later date and time in specificity, but make no mistake, the FDA ruling's big.
Yeah, so that in layman's terms, again, look to simplify a little further, is that the EUA is only allowed to go into effect if there's no other alternatives. So the emergency use of these jabs and the masks and all the other paraphernalia, the shields or whatever else that actually are printed on the box that says it doesn't work, but nonetheless our government is pushing it. I'm from the government, here to help, but so that could not have taken place had an alternative been offered. So the hydroxychloroquine or the ivermectin are definitely treatments for these things, probably more effective than the thing that our government was pushing. So that's very important, which means it creates a pretty grand conspiracy moving forward about what went on with the suppression of free speech and these type of things in order to push and get the EUA authorization.
Well, and that's how you know if you start reading the PrEP Act and you start reading the HHS declarations and you see the revised HHS declarations as of 2023, right, where the HHS has now interpreted its own statutes again and is now removed informed consent from EUA products. Folks, we got to fight this all the way through. And if you aren't paying attention to the Supreme Court and the Chevron deference, you should. Okay, so let's get a synopsis of this particular case. We'll run through this real quick, and then we'll go back to the document. So the holdings was Catherine Kimball Mazzell held that 1, sanitation as used in the Public Health Service Act is limited to cleaning measures. 2, sanitation as used in the PHSA is limited to property. 3, the Chevron deference did not apply. 4, under the major questions doctrine, PHSA did not contain unmistakably clear language indicating that Congress intended for CDC to invade the traditionally state-operated arena of population-wide preventative public health regulations. 5, CDC failed to supply good cause for failure to comply with APA's notice and comment requirement. We're going to get further into that at a later date and time because the APA is the Administrative Procedure Act. And this entire administrative state needs to go the way of the dodo bird. Okay, it's ripe for corruption and misuse and misallocation of public funds, and also directly violates our life, liberty, and property under the guise of general welfare, public good, and public health. 6, CDC failed to provide a reasoned explanation for imposition of mandate. And 7, mandates violation of Administrative Procedure Act warranted of a vacatur. Okay, and I may have butchered that. Okay, so let's begin with historical background here. Okay, and you'll see I quoted the Health Freedom Defense Fund versus Biden out the actual court case. I just want people to know this isn't Brandon's or Gary's 2-2 blog hour. Okay, this is primary source documents, and although MIT, and everybody go verify this, MIT has publicly stated that people who use primary source documents are more susceptible to conspiracy theories that the government is trying to violate their rights. Yeah, imagine that. Objective facts, empirical evidence would lead one to conclude that the government is conspiring to violate our life, liberty, and property. It's amazing. They've said it, not us.
You're a danger to society reading primary source documents.
That's right.
Only government approved reading only.
It is not the intention of the state to educate the populace. I'm trying to remember that quote. I'll think about it. But anyway, y'all can do your own research. It is not the intention of the state, Hegel's state, to educate the populace. And Paulo Freire stated unequivocally that his number one goal was to destroy classical liberalism, grammar, rhetoric, and logic, because anyone that was educated in that field could not be socially and emotionally motivated to become a social activist. So what you see today, although what they're protesting about might be something good, might not be, it doesn't matter. They cannot articulate why they're there. They have no idea. They're being moved with their passions, and therefore it's bypassing their cognitive abilities. So, and be mindful of that when you watch these crazies and cuckoos that just don't throw away just because they're protesting that it's a bad cause. Remember, have objective facts. Some of the things that they actually protest for is a righteous cause. They just have no idea what it is. They're just doing it because everybody else is doing it.
Not one of the ones screaming fascism could define what fascism was.
Not one.
Not one.
Which is the means of production are controlled through public-private partnership. That is Mussolini's direct quote. Okay, that's what it is. That's a fascist society. It's a corporatocracy, which is operating right now through the ESG, BlackRock, Vanguard, State Street, and the public health sector of the military / medical industrial complex, who practice medical asynchronism, which is the destruction of people all across the world. So anyway, I digress. On January 21, 2021, one day after taking the oath of office, isn't that funny? President Biden issued Executive Order 13998, see promoting COVID-19 safety and domestic and international travel. The executive order recognized threats of the continuing COVID-19 pandemic and reasoned that mask wearing can mitigate the risk of travelers spreading COVID-19. Accordingly, the order directed executive officials to require masks on various forms of transportation and while in transit hubs. Approximately 2 weeks later, on February 3rd, 2021, the CDC published the mask mandate without allowing public participation through the APA's notice and comment procedures. How many people know that your state APA has a notice and comment procedure? That your state regulatory agencies. So, and look, folks, I'm not saying that I've been involved with all this stuff for a long time, but it's time for us to get involved. If you're not going to go litigate lawsuits, get involved at your local level and in your state level, joining these APA meetings, right? You can always be a help somewhere. Not everybody's a trial court lawyer. Not everybody's got the mouth of the South like I got, okay? I know my shortcomings, Gary.
No need to speak up here.
So the CDC published the mask mandate without allowing public participation through the APA's notice and comment procedures. See requirement for persons to wear masks while on conveyances and at transportation hubs. As the basis for dispensing with the ordinary APA requirements, the CDC found that it would be impractical and contrary to the public's health. Anytime you see one of these agencies use this wording, public health, it is going to attempt to directly violate your life, liberty, and property. That's where we're at. There's no guys, rip the veil off your eyes. Anytime you see public health, just know that they're coming for your individual rights.
Because it's the most powerful weapon the state can use to subvert rights.
That's
maybe other than the Patriot Act, I don't know, but that was written into the foundation. Public health, if you can make it about that, then you have all these other tools at your disposal. So they try to turn everything into public health and safety and whatever. And there are limits to all of it.
Well, we'll go back to the Constitution, the general welfare. Okay, how did that become public health? Well, there's
language and art.
Mm-hmm. That's right. So when did it become the government's job to keep us safe and assume the risk for all of us? At what point did we say that was a good idea? I'm just asking people a question, because the common law doctrine is the assumption of risk doctrine. That means when I walk out my door, I've assumed the risk of life. This is something we all do. So how is a totally reactionary entity going to actually protect you? They can't. It's kind of like the police. They're called in later, right? And the same idea, the same truth, the same principle about this fact correlates with this, okay? So the mandate also disavowed being a rule under the APA, okay? In the mandate, the CDC explained that COVID-19 spreads very easily and sustainably between people who are in close contact. The spread occurs mainly through the transfer of respiratory droplets from one person to another. Masks, the CDC found, prevent the spread by blocking exhaled virus and reducing inhalation of these droplets. So hindsight's 2020, right? One of the things that they were able to do was make us believe in a complete fallacy that violated our rational, reasonable minds, and that the mistake God made, the thing that was going to save you, was putting paper mache over your face or synthetic cloths. And that was going to be what saved you. Okay? This is unreasonable. This is irrational. And this is illogical. Okay? The man, based on first principles, which is his natural environment, will know that we have one of the most advanced filtration systems on Earth. Okay? and that a piece of paper wasn't what was missing.
Right. And I'll throw in one more thing here. In 1918, when during the Spanish flu, the government spent 2 years trying to spread the flu, and I have a 40-page document from a Journal of Medicine that the state could not successfully spread the flu from one person to another. And they had 100 healthy people and 20 people with the flu, and they harvested all their bodily fluids and stuffed them in all the other people that are healthy. Could not produce a transfer of the flu. And I'll leave that in the show notes as well for anyone to read that wants to.
Okay. So the CDC found that masks are one of the most effective strategies available for reducing COVID-19 transmission. The mandate did not differentiate between kind of masks based on their efficacy at blocking transmission. It simply included a footnote linking to CDC guidance for the attributes of acceptable masks. And, quote, masks can either be manufactured or homemade and should be a solid piece of material without slits, exhalation valves, or punctures. Hold up. There's another rule of interpretation, which is called the void for vagueness doctrine. If you are giving people the authority, right, to make emergency use authorized vehicles outside of a controlled environment that we all know, they could be making this crap out of dirty linen. Who knows what they're making it out of? But this is a complete violation too, because you've granted people to make something at home that is not, there's a term for this, control of, Brandon, oh, doggone it. Somebody will get it, put it in the comment behind. But when you control a document or device and you control it from step A to step B, so you know what happened to it, right? Okay. That's Health Freedom Defense Fund. The APA requires that reviewing courts hold unlawful and set aside agency action that is arbitrary or capricious, in excess of statutory jurisdiction, authority, or limitations, or short of a statutory right, or that was issued without observance of procedure required by law. In a case reviewing agency action, the entire case on review is a question of law, and the district sits as an appellate tribunal. This is where it gets fun, folks, because we got a judge that knows. We haven't had one of these yet, but watch this judge, because they're out there, and this is what we're looking to get to. Judges who understand the rightful place of the creature of statute. Because administrative agencies are creatures of statute, they possess only the authority that Congress has provided. In issuing the mask mandate that requires most persons to wear masks over the mouth and nose when traveling on any conveyance into or within the United States, the director of the CDC relied on a section of the Public Health Services Act of 1944 for authority. That's 42 U.S. Code Section 264A. See also 42 Code Federal Regulation 70.2, delegating regulatory authority under the statute to the CDC. That provision empowers him to promulgate regulations aimed at identifying, isolating, and destroying diseases. Okay? Identifying, isolating, and destroying diseases. The CDC, with the approval of HHS, is authorized to make and enforce such regulations as in its judgment are necessary to prevent the introduction, transmission, or spread of communicable diseases from foreign countries into the states of possessions, or from one state of possession into any other state of possession, for purposes of carrying out and enforcing such regulations. The CDC may provide for such inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals, or articles found to be so infected or contaminated as to be sources of dangerous infection to human beings, and other measures as in his judgment may be necessary. Other sections of the PHSA also provide the CDC with a limited power to apprehend, detain, examine, or provide conditions for the release of individuals coming into a state or possession from a foreign country, or traveling between states, but only when the CDC reasonably believes that the person is infected with a communicable disease and is a probable source of infection to others. So what do we have here? We need objective facts. They would, in order to quarantine and isolate you, they would have to get a warrant signed by a magistrate that you are infected. Okay? Not that it's some presumption. And look, now we're going to get into the social engineering behind all this. There's a reason why they said slow the spread. There's a reason why they told people that your mask doesn't protect you, it protects me. This is social engineering 101. In order for you to believe in anything, they must get you to regurgitate over and over again the fallacy of the statement. Folks, it's asinine to think that your mask would protect you. And so I'll correlate this. Every box, everything everybody picked up had a disclaimer on it that stated this does not protect you against COVID-19. So what do the social engineers do? They reverse engineer that for you to be able to repeat the lie often enough to where you believe it, that my mask doesn't protect me, it protects you. I'm doing my public service, right? And make you feel good about it. But the truth is that it was right there in front of your face. And Yuri Bezmenov states this so succinctly in his demoralization that all you have to do is unplug the banana peels out your ears and listen. The great brainwashing technique is so powerful that you can shove their face in the facts, black white letter, and shove it. They still won't accept it. And I can't remember who quoted it, but y'all can find it. Never underestimate the difficulty in changing false beliefs by fact. It's a true statement.
Yeah, it's a lot like religion. Ever talk to someone and try to convert them?
Yeah.
Absolutely not. No amount of facts is going to change anything for the religious. Yeah. And so this is a religion for people. This coof thing is a religion.
It is. It is a religious. Public health. This is Brandon on his own right here. Public health, first and foremost, is a doctrine of devils intended to subject the individual to social engineering constructs a la Roscoe Pound, Max Weber, etc. So we'll take a quote from Roscoe Pound, who wrote the book, The Scope and Purpose of Sociological Jurisprudence, 1911. Okay? Let that sink in. 1912, a big thing happened. 1912 when Woodrow Wilson come in. This is the creation of the administrative state, by the way, the Federal Reserve and all that good stuff. Just know this is a very volatile time where Americans are falling susceptible to the allure of the carrot, right? Now we're living in the age of the stick, but then it was the carrot, okay? Who doesn't want poverty eradicated and a chicken in every pot and all these ideas? You know, it sounds so good, but at what cost? At what cost? Well, that means the government has to come steal from you. Okay, Roscoe Pound began his pioneering work on a new sociological jurisprudence with an initial presentation of analytical jurisprudence, noting its multiple contributions like the idea of law as something made consciously by lawgivers. 2, the role of force and constraint behind legal rules. So he's already telling you that our individualistic idea of force not being used unless criminal activity has happened, which is physical compulsion or coercion, he's already telling you. Now that concept's out the window, okay? Number 3, this is huge. Read this, folks. The new emphasis on what? Statute law. Oh, where'd our common law go? Where'd it go? Why did the common law go bye-bye? Because the common law already had stare decisis, okay? It already had precedent. So we had to create a new system of laws that could be socially constructed to perfect the whims of this new state, which is antithetical to Americanism, individualism. 4, remember this word I defined for you earlier, the social consequentialist perspective of whatever, say that word. I can't get it out. Utilitarian philosophy. The scope and purpose of sociological jurisprudence, 1911.
Utilitarian.
Utilitarian. There you go. I like it. You just had to hear it one time. Do you understand, folks, the implications here that a Harvard man and a Princeton man, Woodrow, I'm pretty sure it was Princeton for Woodrow, conceptualized the idea of statute law. Okay. And you wonder why we're code pleading now, and you have damnable doctrines such as the actual malice doctrine. And that's 1984 New York Times versus Sullivan, where you can't libel, slander, or defame public figures. Okay, and that includes public officials, because you must be able to prove the erroneous idea of actual malice, right? So this was that particular case was the first case before the National Defense Reauthorization Act, which was Obama repealing the Smith-Munn Act. Okay, so 1984, New York Times v. Sullivan, actual malice is included to get defamation, libel, and slander against public officials. We fast forward to 2012, Smith-Munn Act's repealed, and now you have no way to sue public figures for for willfully and knowingly or maliciously lying to the people. Because
right,
propaganda.
Propaganda. The Smith-Munn Act forbade the U.S. government from using propaganda against its own people. So that's what Obama repealed, and we've seen nothing but. I'm pretty sure it's been violated way before he repealed it, but once that came back, that's where the mainstream media is gone. That's where we know.
They're an arm of the state. That is it. The legacy media is a direct arm of the CIA, FBI, NHS. It doesn't matter whichever one. They're a direct arm of the state. So we are code pleading, okay? And up until this time, we still apply the rules of interpretation. As always, when determining the meaning of a statutory provision, the court looks first to its language, giving the words used their ordinary meaning. This is a huge case. Artist versus District of Columbia. That is a huge case to go read and just get acquainted with the importance of the golden rule. Okay. The opening sentence of 264A grants the CDC power to issue regulations that in its judgment are necessary to prevent the spread of communicable disease. The second sentence informs the grant of authority by illustrating the kinds of measures that could be necessary. Okay, we have an enumeration of powers, right? And then we have where those powers cannot be exceeded. Okay, genius species, right? Remember this as we move forward. Inspection, okay, fumigation, disinfection, sanitation, pest extermination, and destruction of contaminated animals and articles. In other words, the second sentence narrows. Okay, it narrows the scope of the first. You have an enumerated power, and then you have a list of things that it can do. Okay, it narrows it. It's not, and this is the problem with the Chevron deference, because individual agencies can go in and broaden their statutory authority by interpreting their own definitions. Okay, well, I hope Clarence and them boys get rid of it. They need to. Okay. In closing, I'm going to finish this last paragraph, okay? And the importance of this is going to be expounded in the next video, because it'll be all about why originalism and textualism matters, and why we must fight tooth and nail against these religious zealots who fundamentally oppose every aspect of life, liberty, and property. The abolition of all property, as we heard Adolf earlier, that the pursuit of happiness is gone. You know, they want to destroy everything that's good because they hate beauty, they hate life, and they hate capital R reason. Okay. Thus, if 264A authorizes the mass mandate, the power to do so must be found in one of the actions enumerated in the second sentence. Okay. That sentence provides for inspection, fumigation, disinfection, sanitation, pest extermination, destruction, and other measures. A requirement that individual travelers wear a mask is not inspection, fumigation, disinfection, destruction, or pest extermination. And the government does not contend otherwise. Remember, I told you they will not argue the facts. They'll just say they got the power to do so if they want to. Remember Ketanji Jackson? The First Amendment is constraining the government. Yeah, you think so, lady?
By design.
What do you think it's written for? It's an actual limitation on government's involvement in the individual and the people. Hear these people. Believe when a commie tells you they're a commie. Believe them. Okay? Believe them. Instead, the government's argumentation was word games. Listen, folks, you're going to find this every time. You're going to find this every time in every action that you go against. They're going to play these word games, whether it's taxpayer, whether it's person, whatever. They're going to find one thing where they try to broaden it out and try to extrapolate all kind of crap, right? This is the tactic. And if they can get you lost in the circle jerk, like Gary and I did get lost a few times with Carl Bryant. And because it's so ludicrous to the reasonable man, right? It's just, that's why our latest reply to Carl Bryant was what, 12 pages, Gary?
I think 16, but yeah.
Yeah, but it got straight to the point.
Yeah.
Okay, you didn't want to argue this stuff. This is where we're going. It was actually what he didn't say is where we went. Okay, because it's a deflection technique. But anyway, instead, the government, last known precedent, by the way, it's another canon. So the judge says instead it. So we'll go back to the previous noun in a sentence before, and we know it pertains to government. Okay? Last known antecedent is the name of that canon. Instead, it argues that the mask mandate is a sanitation measure or an other measure akin. Close to, maybe not, but it's close, right? Hey, listen, folks. Law is that which is laid straight. It's explicit. It's expressed. That way, the rules apply generally to everyone in society. That's the only type of law. Rule by law, which is consequentialism, is this right here, what I'm reading to you. They can make the law mean whatever the hell they want it to mean. All right. At 671, explaining that the residual clause, other measure, encompasses measures that are similar to inspection, fumigation, destruction of animals, and the like. So we would apply the associated meanings canon, right? The adjustum generis canon. No seek gore. We would apply exhaustive list canon. And all these canons that we're learning, we would apply to this section. And you would know that the restrictions set by Congress to the CDC only included objects, not people. Okay. So the terminology, the correct term for animal is anything without faculties, right? So man is above the animal kingdom. He's not the same thing. We're not even, it's no correlation. So anything with faculties, consciousness, awareness, and the ability to do what man does, which is question existence through our consciousness and awareness, and having 12 faculties of mind, we are above animals. So that doesn't equate. You can't use that. Well, we said animals here. PETA comes in and says, well, animals are worth more than humans. Yeah, okay, that's fine. You believe that if you want to. However, with that said, when we finish episode 2, we're going to finish the rest of this case law. We're going to see a judge, a federal district judge, rule by the rules, okay? By the rules of statutory interpretation, by the rules of grammar, applying common sense to the ruling. Now, there's a reason why the saying goes that common sense isn't that common anymore. That's because most people have been radicalized and intentionally dumbed down. However, that's not you, friend. So, Gary, I'm going to let you close out. Friends, brothers, sisters, we will see you in volume 2 of this study as we continue forward.
Right. So 1 week from today, you'll get part 2, provided Brandon finds the time to record it. But nonetheless, the what happened here, just to close out, is they used the Chevron deference to redefine terms of the word sanitation to apply to humans. And that's how you got the mask mandates or the, whatever else you got. But anyway, close it out. We'll see y'all next week. Thank y'all for joining us. We hope you enjoyed it. Leave some comments in the section so we can improve anything y'all see that we're missing or we need to do extra. Please let us know. We'll see you soon.